Afternoon. Jenner and Block is really happy to host this session. And when I say Jenner and Block, I really mean Tony Valukas, who is our chairman. Tony is a former U.S. attorney for the Northern District of Illinois. He is a fellow of the American College. And maybe his best reason for being here for this joint presentation between the college and the Chicago Bar Foundation is that Tony was the inaugural chairman of the Investing in Justice campaign, which over the last 6 years has raised more than $7 million to provide grants for the kind of work you people do. Some of you work for organizations that have gotten those grants. Tony is the reason you have them. So I'm going to let Tony introduce himself. Thank you all for being here, and then we'll get on with the program.
I love it, Bob. You can do that anytime. All right, let me take a moment because I think you have this incredibly talented panel who you know, and just say a couple things to you. First of all, we had to ask the two associates whose office this is to leave for the day so that you could share this. At Jenner, we believe in larger offices. My heart is with you. What Bob didn't say and probably doesn't know is that where I started out is my first job was with the National Legal Aid and Defender Association. My first responsibilities were to represent and defend the individuals that you do. And I found it to be incredibly satisfying. It is where my heart has always been. I never thought I would ever join a large law firm. That was not where I was going to go. But what you're doing is truly extraordinary work, and it was an absolute privilege to be a part of the Investing in Justice campaign to help raise the funds for people who are doing the real work, and that's you. This is a great opportunity because I'm looking at a panel of people I've practiced with a long time, and there are no better trial lawyers in the nation than the people that you're sitting there with, and so we're pleased, honored to have you here. Those of you who, after 10 or 15 years doing what you're doing, want to come to Jenner, we have offices this size up and down the hall. They're available for you. Get the most you can out of here. This is sort of panel that you're going to really learn from. So thank you very much for being here. Thanks.
Thanks, Tony. Can you guys all hear us if we use these desk mics? Does this work? And I'm going to leave it up to individual panelists. When they do things, they can either go up and use the podium or just sit here and do it from here. Let me just briefly introduce the panel to you so that we don't have to do this each time somebody new clears their throat. As Tony said, this really is a distinguished panel, and I'm just going to go to my right. Jack Cariglio is a fellow of the American College of Trial Lawyers. He's co-chair of his firm's litigation department at Bolger Meckler.
Meckler-Bolger.
Close enough. Whole bunch of people there. He's the former president of the Chicago chapter of the Federal Bar Association. He's a frequent lecturer and speaker on trial practice issues, and he's going to be telling us later during the day about direct examinations. Alan Mills is a graduate of Brown University and Northwestern Law School with honors. Practiced law in a private firm for 10 years, but did a lot of pro bono work. And then he became the director of the Uptown People's Law Center. He is one of you. And he's done this enough that he should be the main teacher, maybe the only teacher. But we're looking forward to his remarks as well. Jim Filio practiced with Tom Foran for a number of years, went off on his own because he couldn't carry the bags of money he was making without some help. Jim is one of the founding members of the Chicago Inn of Court. He's a past president of the Seventh Circuit Bar Association. In 2009, the National Law Journal tracks the top 100 verdicts in the United States. Jim didn't have one of them. He had two of them in the same year. Jim is going to be talking to you about cross-examination. To Jim's right is Tom Demetrio, probably one of the best-known plaintiffs' lawyers in the entire country. Tom is a former president of the Chicago Bar Association. He is a fellow at the American College, as is Jim. I forgot to mention that Jim's a former state chair of the American College. You couldn't get a better panel than we have right now. Believe me, we tried and we couldn't come up with anything better. We also have 3 students from Loyola Law School who are going to be doing something that I hope is a little bit of fun for them and more important for you. One of the perks of being in the American College is that you get sometimes to judge trial competitions of talented law students. And I had the real privilege about 6 weeks ago of going down to San Antonio, and I got to be the judge for the final round of the national trial competition. The national trial competition that's sponsored by the American College started with 310 teams from 155 law schools. So you can imagine that the 2 teams left standing for the final round were pretty good. Unfortunately, the team we have here came in second. They hate it when I say that. In my view, they should have come in first, but it was a razor-thin difference between first and second, and I think that they're champions in every way. Samantha Lemke, Mike DeTore were the second-place team. They are 2 of the 10 Core Boy Fellows at Loyola. Every year, Loyola chooses 10 of its best oral advocates to be on this team, and every member of that team was a winner of at least 1 competition or 2 competitions during the year. They've brought as their witness for their demonstrations that they're going to do today Kyle Flynn, who was the champion of the ABA criminal justice trial competition. So what we have here are people who are not yet practicing lawyers, but trust me, they are good people to observe as a demonstration of the way to do it. It may not have anything to do with the lectures you're going to hear. It may just be something that we throw in, but I think you're going to enjoy all of it. So that's enough of me. Let's talk to Tom Demetrio about openings.
Thanks, Bob. I echo what Tony had to say to you in applauding your chosen endeavors here. Good for you guys. I didn't have that professional accomplishment, if you will. I started right out of law school with a guy named Core Boy. And one of the first things that Core Boy had me do was to go see his mentor, who he learned from, a guy named Jim Dooley, who was on trial. And I, of course, had heard of Jim Dooley. He was the dean, if you will, of plaintiff trial lawyers. And I went over and I saw him, and I watched him, and I couldn't believe what I saw. I saw maybe one of the most boring people I've ever seen. And he had a whiny voice, and he sat down as opposed to standing up throughout the examination of a witness, which I had never seen. And he'd go, "Mr. Witness, you say you," and it was like that. And I came back, went into Core Boy, and said, I don't get it. What am I missing here? And he said preparation. He said nobody prepared a case better than Jim Dooley did. And so I start off by telling you today that our job as trial lawyers is outside of the courtroom, prepare, prepare, prepare. You should be the most prepared person in that courtroom. And then, of course, in the courtroom, our job is to persuade, persuade, persuade. So, jurors don't miss a thing. You need to know this. Before you even get up for your opening statement, they have Googled you, by the way. The court has admonished them not to use their computer to investigate on their own. And I will tell you, though, they Google you, your opponent, the judge, and when you stand up for opening statement, they know a lot about you. That's today's juror. When I started, we didn't have such a thing, so they didn't really go out of their way. But today, it's second nature to them. And so they know a little bit about you. They may know a lot about you. They have to sense that you're sincere. They have to feel your conviction. They have to know you really do believe in your case. Jurors are very, very good at reading body language. You have to walk with confidence. You have to deal with the judge in front of the jury with a great deal of confidence. You have to treat the court personnel with courtesy. Jurors don't miss a thing. Core Boy was a watchaholic. If he had a brown suit on, he had a brown watch on, etc. And we always, and still do post-trial interviews with jurors to learn. They don't know it's coming from us, but to learn about ourselves, to learn about our opponent who we'll face again, a judge who will appear before again. And this one particular jury really lashed out against Corboy. They thought he was a big shot, or he thought he was a big shot, because he had a watch, a different watch every day. And from that day forward, Corboy always wore one watch throughout a trial. So you really do learn from talking to jurors after the fact. But they don't miss a thing. So you need, if you want to really persuade, you have to be prepared. You have to be courteous, competent, professional, and you have to be fair. And by that I mean is in your opening statement, you have to state things that are going to be proven. You have to be emphatic. You have to be detailed, I believe, and I'll tell you why in a few minutes. You have to be confident, and you have to be direct. Now, for years, lawyers, professors would write about opening statement, would lecture about opening statement, and they would say that 80% of all jurors make up their mind based upon the opening statements. And when I started, 1973, this is what I thought was the fact. Sometime in the mid-90s, somebody did a little research, found out that the genesis of that statement was a 1966 survey. It never said what was being claimed. 80% of all jurors make up their mind. Indeed, they don't. I used to think, based on that, it was the most important part of the trial. I now believe that jury selection or deselection is the most critical part of the trial. But then opening statement is a close second. And the reason for that is, while jurors may not make up their mind, they certainly are going to sort of pick sides. They're going to have a sort of rooting for him. It's almost like when you're watching a game you don't really have an interest in. Not the Bulls playing Miami, but maybe Boston playing New York. And before tip-off, you sort of, I think I'm going to go with New York on this one. And so knowing that based upon your opening statements, they're going to sort of maybe favor somebody, and based on that, everything that occurs during the trial, they're going to view based upon, they're sort of rooting for you. And so that's why you can never let them down. You can never say something and then have it prove to be not true. Because once you lose that confidence, their confidence, you lose your credibility. And if you lose your credibility, you've lost the case. Period. The end. If you ever lose your credibility with that jury, you lose. The most important attribute you own is your credibility. And it starts in opening statement. So, justice, now understand my perspective here as a civil trial lawyer, plaintiff's lawyer. But I'm sure my basic belief, which I'm going to impart, applies in the criminal sense as well. Justice is a concept that's hard to define. What's easier to define is injustice. We all know what injustice is. We've all been a victim of some injustice. So I believe the better approach is to have that jury not come up with justice, but to right a wrong, to expose an injustice, because no one wants to be a victim of injustice. and it's easier to see. So I believe it motivates judges. I believe it motivates juries. There's a friend of mine he goes around the country lecturing about the so-called reptile method of arguing a case to a jury, or a case to a jury. And his premise is you have to put the jury in the position of thinking, oh my God, if I don't do the right thing here, this could happen to me or my daughter, someone I care about. But I think that's been going on for hundreds of years, candidly, the so-called reptile method, but without that name. So jurors do want to do the right thing in correcting a wrong. And so that's how I approach opening statement. I let them know there's been a wrong here. It needs to be corrected for the right reasons. Now, the time's limited. I don't even know how much time I have, actually.
You have at least 5 or 10 more.
Okay. I'll just give you some little tidbits that are more global. I never ever say to a jury at the beginning or in the middle, what I'm about to say is not evidence. I don't minimize the importance of what I'm about to say. If you tell them what I say is not really important, they may believe you. They may tune you out. And what if they do tune you out because of that silly comment? Understand the judge has already told them that what the lawyers are about to say are not evidence. They know that. So they may, if you say it, they may think you're being a little condescending. You may think they're not real bright. Didn't understand what the judge told them. So I never mention it. I just go right in. Also, I never say I expect the evidence will show, or I believe the evidence will show. I'm forceful, I'm emphatic. The evidence will establish. The evidence will show. None of this I believe stuff. Let them know you're confident in what that evidence is going to be. Always have a theme. I usually start out with, ladies and gentlemen, regardless of the type of case, whether it's medical negligence, product liability, intersection accident, doesn't matter. My theme never really changes. Ladies and gentlemen, this is a case about safety, or indeed, as you will learn, the lack of it. And it's also about the quality and the dignity of life that has been significantly interfered with due to the negligence of the defendant. I use exhibits in opening statement. I once tried a case where it was a significant brain damage, and the 42-year-old housewife who I represented could not talk. She could not really do anything. And I had her on video on a screen behind me when I was talking about the significance of her damages, and played it, not overly done here, played it for about 1.5 minutes. But it conveyed to the jury more than any eloquence on my part, the significance of the case. So I use exhibits. If it's a stop sign case, I've actually brought a stop sign into the room so the jury can really see, how in the hell did he miss that thing? If it's a failure to monitor the oxygen level, I bring in the equipment. If it's a hydraulic brake case, they're in there. and I'm using them in opening statement. And then I humanize the plaintiff. And by that, I talk about Jim was born on October 1st, 1950. And I sort of breeze through Jim's life and bring him right up to that intersection before that FedEx truck blew the stop sign. I give detailed opening statements for the following reason. When I sit down, I want that jury, all the jurors, to be thinking, even if it's subconsciously, boy, that lawyer is prepared. That lawyer knows his facts. That's the kind of lawyer I'd like if I needed one. That's what I want them thinking. I use words of impact. There was a flash. There was a zone of danger. I give them key phrases that I hope they will remember throughout the trial as they listen to the evidence. Boy, that's what he said. That's what he said 4 days ago. You need to anticipate the defenses. I maintain that you should be able to give your opponent's opening statement in as much detail, with as much conviction as you can give your own. Use video. Practice. If you've got serious problems, front them in the opening statement. Don't you dare let those jurors hear your problems from your opponent. And never, ever make a statement that you cannot prove. It'll come back to haunt you. Stupid little thing. Studies done, these are verified, that brown is considered to be the most sincere color. What does that mean? That means in opening statement, I'm wearing a brown suit. Okay? I don't know. I don't know if it works, if not, but what the heck? Brown suit. Maintain good eye contact. Make sure during your opening statement, at some point, you have made really, really good eye contact with all 12 of those people, 8 of those people, 6 of those people, whatever the jury makeup is. You're in their living room. You're talking to them. I refer to them at the beginning of opening statement. May it please the court, counsel, temporary officers of this court. I let them know from the very beginning that what they're doing is important. Forget the editorials they've read about we need tort reform. Doctors are leaving the state. Forget all that. You're now here. This is my case, meaning the juror's case. This isn't like those cases I read about. This is important stuff. My God, we're temporary officers of this court. So you got to give them, they're making at least in the state, I don't know what you make in the federal, they're making $17 a day in our state court. You've got to give them the sense of importance they deserve. And words are very, very important. You don't say on the occasion of this crash that occurred at Washington and Dearborn. An occasion is the president coming to town or an anniversary. Don't speak with legalese and formality. And then another, this is really digressing. Pet peeve. For the record, Your Honor, I object. What does that mean? You either object or just be quiet. Everything's for the record. But it's habit. We get into these habits. I did NETA early on in my career, which I encourage any one of you to take advantage of. And I watched a tape of myself of a direct examination, which you're about to hear about. And after every answer, I said, okay. I mean, it's like, and I was criticized, of course, should have been. It's like you're saying, okay, you got that answer right. Don't screw up the next one now. But we lawyers pick up habits that we shouldn't. I never ask for sidebars. I don't want the jury thinking I'm trying to keep something from them. Let the judge ask for them or your opponent. The best, I guess, accolade I've ever received after a final argument, an opening statement is, boy, that was the best final argument I ever heard. And all it is confidence. All it is showing a real belief. And don't be afraid to retool. The opening statement you give today was really good for that case, but next week's case may need a whole different approach. So constantly with your friends, your family, yourself if you have to, just keep retooling and read as much as you can. I've read opening statements from people across the country. I'm constantly trying to plagiarize. It's okay for us lawyers to plagiarize, and I encourage that. And if any of you would like some opening statements, feel free to call, and I'll get you a bunch. Okay. So there you have it.
Thanks, Tom. I have to ask your indulgence to just tell one story about Tom, which may or may not be true, but Tom and I have a mutual friend who has told me repeatedly that Tom actually has paid a lot of money to have perfect eyesight. He doesn't need reading glasses, he just uses them as a prop. So when I saw your use of props, I was wondering if you were going to talk about that as well.
Well, that was only before I was age 40 that I did that.
Well, this was a friend that knew you then. We're going to jump right into the demonstrations. The one thing that I want to point out is that you guys are all practicing lawyers. You've all given openings. You've all seen openings. But I will tell you, if you don't already know it, every time you see somebody else give an opening, you will learn something. I learned from watching these students give their openings in April. I expect to learn something today. It doesn't mean you have to emulate something that you think is good. Just put it into your memory banks. This is a way to do it. Now, the problem that they're going to use is the problem that they actually used for the national trial competition. Think Michael Jackson, Conrad Murray. It's the criminal case against Dr. Conrad Murray, but in our case, in part because we didn't want to be sued, the names were changed. And so the performer was named David Kintner, and the doctor was named John Martin. And with that, I'm going to ask the government if it would like to give an opening statement.
Yes, sir. John Martin went from being a physician to a pharmacy. On May 9th, 2011, Dr. Martin's reckless decisions caught up with him when he traded propofol for a poolside cabana and medicines for a mansion. He gave his patient a lethal cocktail of propofol, Vicodin, and adrenaline, a combination that stopped his heart. But to understand why Dr. Martin became so reckless, you have to understand the nature of his relationship with his one and only patient, Mr. David Kintner. Now, as you'll learn today, John Martin met David Kintner decades ago, when the two were just young men. David Kintner was starting out as a musician. He was quickly gaining fame and recognition. And Dr. Martin had just opened up a medical practice. Now, the two hit it off right away, because you'll learn today that as a starting out physician and a soon-to-be rock star, they had similar personalities. And over the years, they spent more and more time together, all the way until Dr. Martin quit his practice and left to become a personal physician for Mr. Kintner. Now, in those years, Dr. Martin was on every tour bus and he was at every concert. He was right there just in case Mr. Kintner needed him. And it turned out Mr. Kintner did need him, because as he aged, Mr. Kintner also battled a widely publicized cocaine addiction. When the two men weren't on the road, Dr. Martin even lived in Mr. Kittner's home. He lived in a 3-bed, 4-bath cabana right next to the pool. And eventually, with a borrowed home from Mr. Kittner himself and only one patient, Dr. Martin became very comfortable. And he did his very best to make Mr. Kittner comfortable as well. Now, on May 9th, 2011, Dr. Martin was at that poolside cabana. He was celebrating his engagement when he got a call from his patient. Right across the pool in the main home, Mr. Kittner was having difficulty breathing. And when Dr. Martin walked into that main home, he could hear Mr. Kittner screaming about pain medications. Dr. Martin walked into that master bedroom knowing exactly what his patient wanted. And it didn't take him long to give it to him. So he pulled out a preloaded syringe that he kept in his medical bag of propofol. Something you'll learn today is a surgical sedative, a highly regulated medication. And in large amounts, this medication has a remarkable hallucinogenic effect. And that's when Dr. Martin injected his patient with not 1, not 2, but 3 dosages of propofol. Now, just a few seconds later, Mr. Kittner began having a violent reaction. He began having seizures, turning white, convulsing on his bed. Mr. Kittner's teenage son, David, walked in and became horrified. He was screaming for Dr. Martin to help his father. And Dr. Martin responded by beginning to go through his medical bag. He was searching frantically for adrenaline, something that physicians are trained to know can bring someone out of a heart attack, except for the heart attack that he himself had caused. As he pulled out the syringe of adrenaline and injected this second syringe into his patient, Dr. Martin told Mr. Kittner, he said, "This is going to stop your seizures." And it did stop his seizures, right at the moment that it stopped his heart. Now, Dr. Martin claims that he didn't inject anything into his patient that day. There are several things you'll learn that prove that only Dr. Martin could have injected his patient with both of those syringes. First off, you'll learn that propofol is a surgical grade sedative, highly regulated, something that physicians have to be trained in anesthesiology to administer. And despite the fact that it's such a highly regulated sedative, it was something that Dr. Martin kept in a preloaded syringe in his medical bag. You'll also learn that adrenaline is the medical response that physicians are trained to use in the emergent care of heart attacks. There were 2 people in the room with Mr. Kittner that day when he suffered a heart attack: his 16-year-old son and his physician. And only one of those people had the medical training necessary to know to administer adrenaline. Lastly, you'll learn that the reason Mr. Kittner suffered such a violent reaction to the propofol is because there was something else in his system, hydrocodone, or as it's more commonly known, Vicodin. Now, Dr. Martin also claims that he didn't know his patient was using Vicodin. But the evidence will show that Dr. Martin had every reason to know his patient was using Vicodin. Dr. Martin knew better than anyone that his patient was a lifelong drug addict. He knew that he needed to look closely to make sure that Mr. Kittner didn't start using one drug in place of another, didn't start using Vicodin in place of cocaine. And you'll learn today that Dr. Martin, in fact, prescribed Vicodin, a prescription that was filled and the bottle found right in Mr. Kittner's room, right on his bed, right next to where he died, and right next to where Dr. Martin had set down his medical bag that day. Dr. Martin was aware of the risks. He was aware that his patient was on drugs, and he still treated him with other medications. He disregarded those risks. He was reckless that day. And because of his recklessness, Mr. Kittner lost his life. At the end of this trial, I'm going to come before you and ask you to review all the evidence that you've heard in this case. When you do, I'm confident that you'll return the only verdict that fits with that evidence and that justice demands. You will find Dr. John Martin guilty of manslaughter.
Well, gosh, I don't know what the defense could possibly say after that, but if you insist, you can give an opening.
I'll try my best. May I proceed, Your Honor?
You may.
David Kittner was on a road to destruction. David Kittner was Dr. John Martin's friend. He was his patient. But he was also a drug addict. And on May 9th, 2011, his reckless lifestyle caught up with him, and he began experiencing a heart attack. He was in pain. He asked his doctor for a certain drug called propofol, a sedative, as you heard. Dr. Martin said, no, absolutely not. And it's after his doctor refuses to give Mr. Kittner that propofol, he convinces his son, David Kittner Jr., to give it to him instead. That drug makes the heart attack he was experiencing worse. Starts to gain steam. A medical team is called. EMTs surround Mr. Kittner, and it's then that he's given adrenaline. But that adrenaline, on top of a lifelong cocaine addiction, on top of a rock and roll lifestyle, a stressful lifestyle, on top of his obesity, it was too much for his heart to take. The heart attack that was already occurring that day stopped his heart cold and killed him. But Dr. John Martin did absolutely nothing on May 9th to cause Mr. Kittner's death. And ladies and gentlemen, I want you to meet Dr. John Martin. Born and raised right here in our great state. He went to medical school here and opened up a medical practice to cater to the members of our state. Later in his career, he met Mr. David Kittner. They became the best of friends. Mr. Kittner even asked Dr. Martin to be his personal physician. He traveled with Mr. Kittner. He lived with Mr. Kittner. Dr. Martin cared for David Kittner greatly, and he is in no way responsible for Mr. Kittner's death. And to understand why he's not at all responsible, we have to understand what happened on May 9th. May 9th, Dr. Martin was where he typically was. He was living in the guest home of Mr. Kittner's estate. He received a phone call from Mr. Kittner. Mr. Kittner said, "I'm short of breath." And so Dr. Martin did his job and starts asking Mr. Kittner questions as to what was going on and specifically whether or not Mr. Kittner had been taking any drugs. Mr. Kittner said no, absolutely not, that he was clean. Based on what Mr. Kittner told Dr. Martin, not what he kept from him, Dr. Martin attributed those symptoms to exercise that Mr. Kittner had been doing that day. Mr. Kittner asked Dr. Martin to come up to his bedroom. And so, of course, Dr. Martin grabbed his medical bag full of supplies and went up to Mr. Kittner's room to check on him. He gets up there and he starts having a conversation with Mr. Kittner. Mr. Kittner's symptoms are getting worse, and that heart attack is gaining steam, though Dr. Martin couldn't have known that at the time. He's still in pain, Mr. Kittner. He asked Dr. Martin for that drug, propofol, a surgical sedative. Dr. Martin, knowing that there's no medical reason to give this man propofol, says, "No, absolutely not. I'm not going to give you that drug." And it's the second that he refuses Mr. Kittner that Mr. Kittner's son, Kittner Jr., storms in the room, screams at Dr. Martin, curses at him, yells at him until Dr. Martin is forced to step out of the room. When he steps out, it's Mr. Kittner in that room. It's his son. It's that medical bag. And inside that medical bag is the drug that Kittner Jr. just heard his father ask for. Sometime while Dr. Martin's out of the room, that drug is put into Mr. Kittner's system. And you heard, in 3 times the medical amount. The amount that someone who doesn't know how to administer the drug would give, not a doctor. Sure enough, when Dr. Martin returns to that bedroom, what does he see? Kittner Jr. with a syringe in his hand, palming something else behind his back as he slips that syringe into his boot. Moments later, that heart attack is in full swing. 911 is called. EMTs arrive, surround Mr. Kittner, and it's then he's given adrenaline. But that adrenaline, that propofol, the years of cocaine abuse, the obesity, his age, the laundry list of health risks for a heart attack that Mr. Kittner had, well, it was all too much. The heart attack that he had began experiencing before Dr. Martin even got to that room stopped his heart. And he died. Dr. Martin's friend for decades is dead. And that's what happened on May 9th. Despite that, the state is here alleging 2 things that they have to prove to you, members of the jury, and they have to prove them beyond a reasonable doubt. And make no mistake, that's a high burden. They have to prove to you, 1, that it was Dr. Martin who injected the drugs that day, and 2, that it was actually those drugs that caused his death. And to try to prove, in an attempt to prove, that it was those drugs that caused Mr. Kittner's death, they're going to bring forth a doctor, Dr. Chris Jensen. Dr. Chris Jensen performed the autopsy of Mr. Kittner in this case. He's going to take this stand and tell you, members of the jury, that despite all the health problems we've been discussing, despite Mr. Kittner's obesity and his age, despite that he was at risk for a heart attack at any given day, any moment, any time, that it was just these drugs that caused Mr. Kittner's heart attack. What you're going to hear is the evidence is not going to support that. The state's going to fail to meet their burden because Dr. Martin didn't inject a single thing into Mr. Kittner that day. And two, we don't know and we can't know what caused Mr. Kittner's death on May 9th. And after you've had a chance to see that for yourself, you're going to have a duty, an important duty. A duty to return a verdict that fits with the facts you'll hear, the evidence you'll hear. Most importantly, and have a verdict that fits with the truth. If you do that, there's only one conclusion you can reach. Dr. John Martin is not guilty.
Thanks, Mike. Thanks, Samantha. Alan, I'm going to ask you to weigh in on what Tom said and what we just saw in these demonstrations. How do these folks apply it to their practices?
Well, I mean, I don't think that it's real different than what people said, so I just want to add a couple things, maybe to make it a little more specific. First of all, Tom is obviously a plaintiff's lawyer, and we do a lot of defense work. I personally do a lot of landlord-tenant, defending the tenants who are being evicted. So in that sense, you're responding to the other side. So I absolutely agree, you've got to be able to give the plaintiff's opening statement as well as you give your own. But you also have to react to what they said. I think it's important not just to ignore whatever they said in their opening. And I always try to start with something they said that I think is wrong, and then I think the evidence is going to be wrong, pick up on something they've said. So you're responding to it directly and get going from there. So it doesn't sound like you're giving a canned speech. And I think visuals are key for all of our cases. I think that we tend to get busy, and therefore we don't get up from our desks enough. I think it's important that one of the ways you convince a jury of something is with pictures in their own minds. That may mean a picture of the scene, it may mean a map of the scene, it may mean the car or the physical stop sign you've got, that's great. It may mean just a picture of the building if you're talking about an eviction case. It may be a picture of the kid if you've got a kid who's not there. Whatever it is, try to you want to be able to visual it, so you've got to go out to the scene itself so you can paint the picture for the jury. It's really hard to describe something you've never seen yourself. And then whatever visuals you've got, try to visualize it. Try to bring something into the courtroom that makes this real. The other problem we often have is we have what used to be called damaged plaintiffs, damaged clients. Often you're not dealing with the people that the jury can identify with really easily. Often you're dealing with very poor people, or in my case, we do a lot of prisoner civil rights cases, so you're talking about a criminal who's been convicted of a crime. So you're starting off with somebody who the jury may not have an immediate connection to. So part of your goal is to humanize that person, to find something that is the same in your client as the jurors is. So maybe they have a job, talk about what their job is. Maybe they're in school. Maybe their kids are in school. They raise their kids, whatever it may be. Try to find something that's going to make your client seem like everybody else in this room, that they're not these monsters that they talked about in terms of prisoners, or they're not just ne'er-do-well tenants who are trying to live off the system, or whatever it may be, so that you can humanize them and use the specifics of their lives. Not just, oh, they've got kids, but they get up in the morning, their job is to, at a manufacturing plant, this is what they make, this is what they do. Those details are what build your case, build credibility. It's you're trying to use words that sound like you're drawing pictures for people. And that's not the conclusions, it's the facts. It's what people would see if they were there. You want the jury to feel like they are at the workplace, that they're in the apartment, that they're right there with the police, or whatever it is your case is about. You want them to be able to visualize what it would be like. So it's those descriptive words, it's those action words. It's not and these openings were great. None of them said ever, this witness is going to say so and so and so and so. That's not useful. You want to say what the facts are. Forget who's going to testify to it, but what are the facts? What is it you're going to learn? What happened? You're going to use those action words. You're not going to say, I'm going to put on a witness who's going to say blah, 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 blah. It happened. You're the one testifying at this point. You're the one who's telling the jury what actually happened. Then they'll hear it again from the witnesses later. But my bottom line is always get out of the office, see the physical spot you're in, make sure you know the facts better than the other side does, which in our cases, often the other side is just as busy as we are and often busier. So it's important for us to understand the case really well so you can use those details to convince a jury that you're right.
Thanks, Alan. We had sort of planned on letting the entire panel talk about this, but to get us back on track, I'm going to jump the panel discussion and ask Jack to talk about direct examination. It may well be that opening statement is the most important part of a trial, but anybody can get up and talk about what's going to happen. Direct examination and cross-examination are where the real skill of a trial lawyer come in, because you either get it right or you don't get the evidence in, and if you don't get the evidence in, you got nothing to talk about in closing, and everything you said in opening was a bust. So let's hear how to do it.
Thank you, Bob. Well, there's two views as to what's necessary for, and I'll expand it a little bit, what's necessary for a great opening, direct examinations, cross-examinations, and I would suggest to you that let's just take a look at one of the views now. I'm not saying that it's the one that I endorse, but if you just look at the flyer, the invitation for today, you would see that the words on opening statements were brought to you by Tom Demetrio, and you should probably know that Tom was nice enough to pinch hit for a lawyer who couldn't be here today, Mike Monaco, a great trial lawyer. My name is Jack Cariglio. I'm presenting to you on direct examination. You will soon hear from Jim Filio on cross-examination. So one view of great directs and cross and openings is that your last name has to end with O. So you might say in response to that, well, we have great lawyers on this panel by the name of Bob Bynum and Alan Mills, and I'll leave it up to you to research their family tree to see if that name was shortened at some time. So that's one view. It's not the one I would endorse, though. And I confess to you, we did not compare notes before we came here today. So you heard from Tom Demetrio about the need to prepare, and preparation is the key word, and the key word that I would give you on direct examination. It doesn't matter what your name is. Hard work and preparation is the key to the whole trial practice, especially so with direct examination. We could argue all day about what aspect of the trial is the most important or what surveys show. I'll just share with you my own feelings that I don't think you're any more nervous during a trial than during your direct examinations, especially if it's your client. I mean, when you think about it, the opening statement, it's you. You have control over it. You can study, you prepare, you get your words ready, and hopefully it goes well. And just think of, let's say we had a scenario here where Tom Demetrio just got up and gave an opening statement against my client. And let's just say I'm the plaintiff. So after going through a Tom Demetrio opening statement and taking the body blows from that, I'm going to call the first witness who's going to be my client. And I know that waiting in the wings, just drooling to get at him, is Jim Filio, who's going to do the cross-examination. So to say that there's a little bit of pressure on you when you're doing direct examinations, especially of your own client, that's an understatement. The focus also is on the lawyer. It's sort of all on you. If the story that your witness tells doesn't make sense, that's your fault. Even worse than that, if you ask some questions that, God forbid, you don't know the answer to, and you get an unexpected answer out of your own client or your own witness, well, that's your fault too. Cross-examination, you'll hear from Jim in a moment, Sure, it's an uncooperative witness, it could be the opposing party, but you're entitled to lead that witness. You have some mechanisms to control the witness, and with some judges at least, you can lock them into yes and no type answers, which makes the examination very, very effective. So, as far as preparation goes, I think you just saw a great example of it with the law school, the law students who did their opening statements. Obviously, they weren't standing up there without notes, just winging it. They had prepared those statements over and over and over again. So how do you start for a direct examination? Well, what I would say, the initial preparation, you want to tell a story with every witness. So you start out by outlining your story. What do you want this witness to tell? It's not like a book, it's a little more like a screenplay. It has to be concise, it has to flow, it's questions and answers. It's a condensed dialogue. Probably the worst thing that you can do with a direct examination is just say to yourself, well, I do a lot of depositions, so since I know how to do depositions, I'll do a direct examination at trial like it's a deposition. We all know what depositions can be like, especially if they're truly discovery depositions. There's a lot of wandering, there's not a lot of thought that goes into the questions. Sometimes you're asking questions, you really don't know what the answer is going to be. You can be a little bit all over the place in a deposition, and no one is going to necessarily fault you for that. It's different in trials, and it's different in a direct examination. You have to focus on the important points, it has to flow, and you have a limited amount of time. Every judge, and especially juries, they don't want to see examinations go on forever. They want you to get to the important points as soon as possible. So what do you want to think about in weaving into your direct examination? Well, Tom Demetrio mentioned the credibility factor. You want your witness to have some credibility. You want the audience, whether it's the judge or the jury, to believe that this person is telling the truth and what the information they're giving is accurate. So you think in your own lives, how do you, if you're meeting someone for the first time, what is it that makes a good first impression on you? What tells you that someone is credible, that someone's truthful? You get some background on your witness, and it could be a number of things. It could be, where they live, something about their family. Were they in the military? And where they went to school. And you don't have your blinders on. You pay attention to, you always pay attention to who your audience is. If it's a judge, you're going to have done some research on the judge, some prior decisions, the background of the judge. If it's a jury, and you've just gone through the voir dire, you know something about the people. You may know, for instance, and Jim Filio and I worked with a great trial lawyer by the name of Tom Foran, who was a Navy fighter pilot in World War II. Well, when a member of the jury panel said that they had some military service, there was an instant bond there. And certainly if any of the witnesses, someone you're doing a direct examination with, was in the military, you would want to accent that. It gives some credibility, and you know there's going to be at least one person in the audience who's going to have a high respect for that. So those are the types of things you do. What exhibits need to be either admitted or certainly highlighted through the witness? You've got to outline your story. Not only what testimony will you get through the witness, what exhibits do you want to get through this particular witness? Will the testimony be consistent with the prior statements of the witness? You certainly, don't want to present a direct examination that sounds good at trial. It sort of flows nicely, but a small detail, a year ago in an affidavit, that witness said the exact opposite thing. That's not going to go over well for you. So you have to capture the depositions, the affidavits, the emails, the correspondence, basically from the exhibits that will be used at trial, and make sure that what your witness is going to say squares with what they have said previously on the same topic. You have to vet your witnesses. There was the movie Game Change with about the Sarah Palin vice president nomination, and there was some criticism that that there were too many surprises. They didn't do enough to vet their candidate. You have to do that with your witnesses and be familiar with their prior statements. Will the witness corroborate other favorable evidence you have? You need to work on that. If there's an important meeting and you have more than one witness on that subject, each direct examination has to hit that and corroborate with what the other witness said. Will the witness refute contrary evidence? Denials are important, and sometimes they need to be emphatic. So if you're in a case involving a domestic dispute, the question would be, did you ever threaten your spouse? That is a key to the case. The person either did or didn't, and you have to, that's also working on your own delivery and that of the witness on a question that is that important. So after you do this initial prep, after you do this outline, after you have your story ready to tell, what's the next step? The next step is you have to really sit down and do a Q&A. You have to write out or type out your questions, and you have to type out the answers that you believe your witness will give. You're going to have, for your first draft, you're going to have some blanks. You're going to have to fill them in through working with your witness. But that is the way to do it. The people who think that they can just really get up there and wing it usually get a surprise that they don't like at the end of the day. It does not work. As you work through your Q&A, you refine it. And also, as you are preparing your direct examinations, you're also thinking ahead that while it would be nice to be able to put your client on, do a direct examination, and then everybody sits down and you just go on to the next witness, there's a little thing called cross-examination that your witness has to survive. So while you're preparing for direct examination, you're also preparing your witness for the onslaught of cross-examination. Part of it would relate to something that Tom Demetrio said about opening statements. You want to be prepared for the bad things that are going to come out in your case. And rarely are you going to have a case where all the evidence just lines up perfectly for you. How do you do that in direct examination or with the witness that you're presenting through direct examination? There's really two ways. One is just to confront it. I had a case once involving a person who owned a business that owned a number of restaurants, being sued by investors, and that person lied to one of the investors when being questioned about how many people were coming to the restaurants. And it was apparent, it was going to come out. So we confronted it during the direct examination, had him admit that he lied. And what was the reason for the inaccurate statement? The investor was driving me crazy, would call me 19 times a day, wanted to hear that there were at least 100 people in that restaurant on Tuesday nights. So I said, yeah, there were, even though it was a lie. We got it out. It wasn't the greatest thing in the world, but it was better to front it, to let the air out of it than to let it go. There will be some times that you'll prepare your witness for something that's going to be troublesome on cross-examination. I had another case where I represented a Japanese company that was accused of employment discrimination favoring Japanese over Americans. The Japanese executive had testified in a deposition that he thought he had a job for life, which is not a good thing in an employment discrimination case of that nature. We knew it was going to come up on cross-examination. We also knew that we had a judge who had some latitude and gave some flexibility to how witnesses answered questions, even on cross, that he wouldn't just hem them into a yes or no. So that came out on cross. The witness was prepared for it. And when the witness was asked the question, well, you believe that you have a job for life, just reading right out of the deposition transcript, the witness's answer was, well, after working 35 years for the same company, I guess I think I have a job for life. Better than the deposition, a much more reasoned answer, even though it wasn't the best. It helped. But it didn't just come naturally. It came through preparation, thinking about it, and having the witness ready for it. Once you have your questions and answers written out, and you're getting ready for trial, you rehearse your testimony with the witness. And rehearse is not a bad word. It doesn't mean that you're making things up or that it's not true. It just means that you're going over it and over it to make sure that it comes out and it flows. You want your presentation to be dramatic. You want your presentation to be smooth. Don't assume that because that your witness is just going to get everything because they were there, because this is about your witness's life. As you know from your own trial experiences, frequently the events are from the past, sometimes a long time ago. People forget. They need to be reminded, especially if there's a lot of documents or a lot of emails on a topic. So you have to work very, very hard with your witness. Long narratives aren't going to work, and nor will leading the witness. You're not allowed to do that in direct examination. So there has to be significant preparation time put in. And I guess on the other side of it, don't just assume that because your witness, maybe you'll have a witness who you think is smart. Oh, well, they're just going to pick up on things. This will go well. We won't have to prepare all that long. The most frustrating experience when you talk about dealing with people who are supposed to be smart, try a case once where the witnesses are lawyers. It's the worst experience you could ever have. I had a case once, and I know other people here have done that type of work. It involved the breakup of a large law firm, so that every witness was a lawyer, including many of my own. And you have to get through it in the prep session, because the prep session would go something like this: what's your name? And they launch in on their closing argument. So you need to prepare people. It's one question at a time, and you need to work with them on it. Describing scenes are the scene of an accident, the scene of a landlord-tenant dispute. You need to do that in direct examination. I called Alan a couple of days ago to talk about the type of cases that he has, the type of cases that many of you work on, and frequently the best way to describe a scene and the easiest way to do it is through a photograph. Get photographs, and sometimes self-help is the best. Before you try a case that would involve a scene or a building or someone's apartment, you want to visit it yourself. You want to be able to see it, and you can snap pictures of it. you can use those pictures in your direct examinations, and as long as the witness is familiar with the scene from when you took the photograph, they can put it in, help you put it into evidence through their direct examinations. You will find that not only will you want to get exhibits admitted in your direct examinations, the more important ones, you'll want to make sure they're published, especially if you've got something that's really good. You'll want the judge or the jury to see it and to spend a little time with it. And you have to build that into your direct examinations as well. When are you going to pause? When are you going to publish exhibits? Give time for the reader, for the audience to see what you're doing. There's a lot that can be said about, okay, writing out the actual questions. I don't want to be leading. A frequent objection is hearsay. How do I avoid hearsay? Obviously, in our everyday lives and everyday conversations, what did Joe say when he went to the White Sox game the other night? Well, you can't, even though we would normally talk about that in conversations, if you're going into what a third party said, it's hearsay, and unless you can come up with some exception, you're not going to be able to get it in with your witness. You've got to work on that. You have to figure out what the evidentiary foundation is for every question that you're going to ask, anticipate if you're going to get objections. Laying the foundation for the conversations that you want to get in. Being ready to refresh recollection with documents if your witness needs help remembering something. I would commend to your reading one of the materials that is in your booklet in front of you is Presenting Testimony that's written by Bob Bynum. Very good for the mechanics of how do you deal with these evidentiary issues? How do you write out questions and do an examination involving issues that could provide some touchy evidentiary items? So I read through that. I'm sure when you see the examinations that will take place, from our law school students, you will see a great deal of thought was put into it, a great deal of preparation, and probably something I should mention now is obviously in the opening statements that you saw, and you may see it too in the examinations, they don't use notes. Well, in those openings, they prepared them over and over again. It's using notes, especially in direct examination, is somewhat expected, somewhat necessary. It's not a bad thing. But then again, you want to know your case well enough, you want to know your examinations well enough that you're not just sort of stumbling through or just reading something verbatim. And you also have to have the flexibility that if the witness doesn't give you the entire answer that you're looking for, you have to have the flexibility to ask a question that may not be written in, a follow-up question to make sure that you get in what you intend to have admitted through the direct examinations. Will witnesses make mistakes? Sure. They will, and it happens very often. Part of the delivery of a direct examination, this time period when I say you're going to be very, very nervous because it's your own witness, your own client, you have to keep a poker face. You can't let your audience, whether it's your judge or your jury, know that the witness just messed up on something. You just keep going. You improvise. You find a way to deal with it. You try to help the witness when you can. If they get stuck, what happened next is a popular question. Landlord-tenant issue, let's say. Well, what, if anything, did you do after you learned that the landlord refused to repair the leaks in the ceiling? Try to keep it flowing. Try to get them on to the next thing rather than just get stuck on one subject.
Hey, Jack, I'm sorry to do this
Yep.
to you, but there's so much to say about
Yep.
direct, and we've got some other stuff to do, so.
I'll end it up. The last thing I'll say on it is redirect examination. The best is none. If you've prepared well, and you probably won't need any. If you do, use it sparingly to clarify, to correct. And then I think you'll have an effective direct examination. Thank you.
Thanks, Jack. My heartfelt apologies, Jack, for making you abbreviate that, because there really is so much to say, and we've tried to cram a lot into this. Since you raised these little booklets of materials in front of you, let me just say one quick word about that. We threw some materials together that are basically a bunch of old articles that were written, some of them somewhat recently, some of them a long time ago. The one on opening statements, for example, is nearly 25 years old. And the basic rules of opening statements don't change much, but if you have nothing better to do and you actually read it, you'll see that the article touts the use of demonstrative aids like blackboards during opening statements. That this was written before PowerPoint. Now it is malpractice not to use a TV screen and PowerPoint and computer-assisted things if you've got a wired courtroom. I don't know in your practices whether that happens all that often, but it will happen. It'll happen more and more, and you have to be used to the technology. You also have a handout, which is a chapter from a book that Jim Filio was the co-editor of. It's a book in which 50 Chicago trial lawyers authored individual chapters, vignettes about cross-examination. Jim has brought one of those vignettes for you as a handout. Oddly enough, it's the one that he authored, despite the fact that there are other people in this room that had chapters in this book, but apparently in Jim's opinion, his is the best. And now he's going to tell you what.
Well, I also note that this book has all of the royalties, all of the proceeds from this book goes to the Chicago Bar Foundation, which is one of the sponsors of this program. Well, good afternoon. I have the pleasure and the honor to address you. You are all lawyers. You are all doing good work. You're representing people in situations that where they need lawyers, where they need a voice, and you can be that. So I applaud each of you. I'm talking about cross-examination. Cross-examination, to me, is fun. It's probably the most fun part of any case. But to be effective, it's got to relate to the whole case. Cross-examination really is just part of what you're trying to do. And in order to be effective, it's got to prove a point. Too often, we might get attracted by the opportunity to impeach a witness with a prior statement and build a whole cross-examination around that one impeachment, but it may have nothing to do with whether you're going to win the case. And therefore, it's not effective. So know your case. I've tried to come up with some points here because I know a lot of cross-examination advice and lectures assume that you have a lot of resources and a lot of time and a lot of stuff that you can craft this wonderful cross-examination on. I'll bet you don't have that opportunity very often. So I kind of tried to develop some things that are cross-examination on a shoestring. And that's what I'd like to talk about, how you can be effective when you don't have a lot of time, when you don't have a lot of resources, but you're still trying to win your case. So you want to know your case. I'm going to give you a few things that are important no matter what kind of case it is. You want to know your case. What do you have to do to win? Tom talked about themes. I think themes are incredibly important. My favorite theme that I try to work into almost every case, and it usually works, is this case is about an abuse of power. Now, if it's a government case, this case is about the abuse of the power of government. If you're representing a tenant who's getting thrown out by the landlord, this case is about the abuse of economic power, or whatever it is. I always try to find out whether you're a defendant or you're a plaintiff. It's about an abuse of power. That's a nice theme if it works. Now, sometimes when you get a case, and you don't get to choose a lot of your cases, I would guess, it's a fairly dismal story. You really have to struggle to find what kind of defense you have or how you're going to win. But I believe that every case that's going to be tried, that there is at least one essential truth that would win your case. And that's what you have to find, that essential winning truth. You may not have any defense on liability in a particular case, for example. But there may be something on cause. You know, sure, they did all these terrible things, but they didn't cause the problem. And so your focus is on cause. Or the essential truth may be damages. Maybe there was liability. Maybe there was cause. But come on, it's not as bad as you say it is. You know, these damages are exaggerated. And they're exaggerated because there's a greedy person on the other side trying to rip off my client and using the system. You know, that's an essential truth that might win. Maybe it's just, oh, come on, this poor person, leave them alone. You know, maybe that's all you got. But find your essential truth and build your case around it. Now, in cross-examination, I'd focus on knowing your case, knowing how the cross-examination is going to fit with it. Know your judge or jury. If you have and in fact, if you have a judge, even if you have a jury, know your judge, because the judge is going to influence how you can effectively cross-examine. The rules of evidence will apply, and you should know them, but judges are the ones who make the rulings, and you know, I don't know where they come from sometimes, because I think I know what hearsay is, but I swear, almost every case I'm in, I get a different ruling on what hearsay is. So I'm bruised enough to know that, okay, I'm not going to change this judge's view of hearsay. So let me try to understand it. Okay, that's what you think. Now I know the rules. And then I play with that. I just go with the rules. It's like refs or umps. They have different strike zones. They have different idea of what's a hard foul or a flagrant foul or a technical foul or who's getting thrown out of the game. So you have to know who your ref is, who your judge is, and act accordingly. That means a lot in cross-examination because you don't want to be going down a path and have the judge interrupt you or stop you through an objection. You've got to anticipate it a little bit and be able to try and work around it. So know your judge, know the witness. Some witnesses are really good people and really nice witnesses. Those are very difficult people to cross-examine. And when you do that, you have to be a little nicer. If, on the other hand, the person's a scoundrel and a liar and arrogant, then, you know, you can have some fun. You should still be respectful, but not too respectful. Know yourself. Know what your strengths are. You can't be somebody else. You have to be yourself. I think there are some things you can try to do to be more effective within your personality. I think it's important to speak clearly, to speak with some volume, but not the same volume. Modulate so that you can keep people's interest. And if you want to make a point, speak loudly or maybe very softly. So that's helpful. Because you want the jury to hear you or the judge to hear you. And frankly, I think you probably try more cases to a judge than to a jury. I treat judges like jurors. I don't change what I do because they are people. They want to hear facts. They think they know a little bit more than everybody, but they still need to be persuaded and want to be entertained. And cross-examination can sometimes be entertaining. I want a jury or a judge, when I stand up to cross-examine, and I pause, after the first couple cross-examinations, I want them to say, okay, here we go. This could be fun. You'd want to just create that little sense. If I feel that from a jury when I stand up there, that's a good feeling, and you're moving because you're starting to build a bond with that jury. You have credibility, and they want to listen to what you have to say. Know your documents. I don't know if you guys will have very many depositions to use, but you usually have some documents. And I'm involved in the case right now. We're in the middle of this trial, and it's been going on for 52 days. It's a bench trial, federal court here. And I represent the city of Joliet. General Black's about on the other side representing a couple of tenants. Shriver Poverty Law Center is representing a couple of tenants. Department of Justice is involved in the case, and the Gidwitz family who owns this Section 8 subsidized housing project in Joliet that Joliet is trying to take through eminent domain is represented by a big firm here. And that's been fun. That case has been fun because they're accusing the city of Joliet of discrimination, unlawful discrimination, and that they do not have a valid purpose for taking this property. And they're wrong. And
Then why are you still trying?
because they don't agree with me yet. It's really terrific case. It is so much fun in that case because the evidence is so powerful, and yet I don't get it. The government doesn't seem to want to fold, nor does General Black. But we'll see. I'm going to give a couple of examples from that case to make a couple of points on the how to do it, because you have to know those things. You have to be prepared. Now, how do you do a good cross-examination? You want to be prepared. We've all heard that. You want to know how it's going to fit in the case. You want to be organized. What I like to do in a cross-examination as I study it, and this can be whether it's an important witness or an unimportant witness, whether you have a lot of time or not, is identify the topics, the points you want to make. I want to, okay, this is a witness, knowing the case, knowing the documents I have, I want to make these 5 points or 4 points or 10 points, whatever it is. And then within each point, you should get a folder or however you organize yourself. Get something that has the stuff that relates to that point. Outline of how you want to get there, exhibits that you may need to use, deposition, testimony, or prior statement that you may want to use to control the witness or impeach him or her. But have it organized, and then you can pick the way you want to organize the points. They don't have to be chronological, but usually that makes sense, and you really want to know your judge or jury. If they like it chronologically, you do it chronologically. But so you want to get organized, and then you want to perform. You want to deliver on each of those points. And there's no one size fits all on that, because it's so dependent upon what you have and who the witnesses are. But you should have a couple of ideas. You should have you should practice, if you have time, practice with a colleague or a friend, have them play the role of the witness, which everybody hates to do, but then you can cross-examine, try out a few things, because there's so many cross-examinations I've played in my head that are so awesome that, you know, I talked to one of my partners or colleagues about it, and they're playing the witness, and it just, Jesus, it's not working. It doesn't go. I got to go back and figure this out. So that helps a lot to get a dry run on that. Have a couple of escape routes, because it's not going to work a lot of times. Your cross-examination, your points are not going to go the way you want them to. So and you don't want to go somewhere and get a bad answer and go, Jesus, you know, what am I going to do now? You don't want to communicate that. You want to communicate, of course, and then have a nice little transition into something else where you can maybe score a point. So have some escape plans and transitions. Just one suggestion on how to use documents. You know, obviously you want to get documents into evidence. That's the easiest way to use them. Sometimes there's documents that you want to use on cross-examination where, you know, maybe a 5-page document, you want to use 2 sentences. The rest of it is not good for you, and it's not in evidence yet. And you don't want to be putting it in evidence, but you want those 2 sentences. You can't really get it in the document. So what I've done, and it's worked a lot, it doesn't always work, but is to ask the witness if these 2 sentences, you know, are, if he remembers those. And often you'll get, I don't recall, I don't know. And then I use the document to refresh his or her recollection. And the way you do that is you show them the document, you mark it as an exhibit, but you don't offer it into evidence. You ask them to read that. They can read the whole document if they choose, but if you could focus on page 3, paragraph 2, and then if you could put that down. Now I want to ask you a couple of questions. Now, does that refresh your recollection about this, that, or the other thing? And you will find very frequently that if a witness sees something in writing that they either were copied on or that they drafted, their recollection, while it may not actually be refreshed, they will answer as if it has been refreshed. And then you have it in, and you don't have to use the document. You take it away, you put it down. You haven't offered it into evidence, and you move on. That's just one thing that seems to work a lot, and judges tend to allow you some leeway on that because it's not coming into evidence. And they'll tell you, and the law is that you can use anything to refresh somebody's recollection. Some examples of things. We've talked about meetings. A lot of times you'll be at part of a case is going to be what was said at a meeting. And it could be really important, what is said. And there might not be a lot of corroborating evidence on it. So you're trying to cross this witness. In this case, one of the key witnesses in this case from HUD was on the witness stand. One of their evidence was that a city councilman from Joliet purportedly said at a meeting that we want to take this property and get rid of all those rats from Chicago. And they used that as evidence that the city of Joliet is racist and that it wants to get rid of the poor in Joliet. But there's nothing in writing about that, okay? So then, this is early in this process that leads up to the condemnation. So I'm cross-examining this guy. I said, now, at that meeting, were you offended by that? He goes, yes. That was outlandish. You ever hear any city official talk like that? Never. A city official talk like that. That was horrifying to you. He goes, yes, yes. So when you left that meeting, you went to your office and you prepared a memo that set forth what was said and the person who said it. So you'd have that, and you could send that around to others at HUD, right? No, I didn't do that. Well, you certainly wrote a little note to yourself about this and identified who said it. No, I didn't say it. Well, you certainly talked to your colleagues and said, you should know this because this is outrageous. And he says, no, I didn't. Did you ever call anybody? Did you ever tell anybody? No. What you did do some things though, right? About a month later, you wrote a status report where you talked about the status of things with the city of Joliet and the ownership and the efforts to refinance this property and the city's objections. You wrote that, right? Yes. And you said that you tried to be complete and honest in that, right? Yes. I did not see any reference to this statement that you claim was made. Because it's not in there. And then I just, moved on to something else. But that can be very effective. And you can do that in a variety of things because a lot of people just don't, well, they make things up. And then they have a later recollection of it. But the facts, the real world, doesn't corroborate what they're saying. And that's an effective form of cross-examination. Without deposition testimony, without prior statements, but just what would normally happen if you were telling the truth. What would normally happen? And if you can point out the circumstances that say, if that really happened, that person would have done something. So that's a form of cross-examination that doesn't require any prior inconsistent statements at all. The same witness talked about an inspection that had been done that found that the property was, an inspection by the federal government that found the property was not decent, safe, or sanitary, that he declared was out of standard. And so took it out of their system. Didn't tell us about it until trial. So on cross-examination, I said, now you declared this inspection was out of standard. What was the standard? So well, it wasn't any written standard, but it was my experience. I said, well, what was it? And he had already testified to this. So that it took 2 days. So it took more than a day. And normally those inspections only take a day. And so I said, well, that's the reason it was out of standard? Yes. Is that the only reason it was out of standard? That's the only reason. That was important to you? Yes. And that's the only reason, right? And so you took it out, and that's an unusual thing to do, right? To take it out of standard. Yes, yes. Okay. Now, you rescheduled that inspection, right? Yes. Here's the letter rescheduling that inspection. You didn't write it, but the inspectors wrote it. What does it say? Scheduled for July 16th and 17th? 2 days? Yes. And then I just paused. Did you declare that out of standard? No. Then I shuffled some papers and asked a couple other questions. Another witness, another HUD official in different circumstance, but and this you can do because the credibility of the witness is important. And this just happened because this was not important to this case at all. But there was an important meeting, separate meeting, and this guy had written a memo a few days after an email saying, "Hey Rick, help me out. Secretary Martinez has tasked me to help find a middle ground to help the situation." Totally innocuous. Who cares? But he said something on direct about it was my idea to find a middle ground. And I expressed that at that meeting. So I'm asking, so in the morning we start off and I say, You testified that it was your idea to find a middle ground? Yeah. Well, that's not true, is it? Yes, that's true. No, it's not. Secretary Martinez ordered you to find a middle ground. That is not true. Secretary Martinez directed you to find a middle ground. You said, no, he didn't. Secretary Martinez instructed you to find the middle ground. No, he did not. Secretary Martinez tasked you to find the middle ground. That is not true. Let me show you this email. It says, Rick, Secretary Martinez tasked me to find a middle ground. Could you help me explore some ideas? Did you write that memo? That email? Yes. How many days after the meeting was that? 6 days. Now, this is something I did that I don't normally do. I usually stop and move on. But I said, you want to change your testimony? Because it really wasn't an important part of the case. Let's try to be kind of a nice guy. Do you want to change your testimony? No, I don't. The judge looked at him and said, did you hear his question? And he goes, yes, Your Honor. Do you want to change your testimony? No, I don't.
Jim, I apologize for being...
Okay, I'm gonna wrap that up on that, but know your case, enjoy what you're doing, be prepared, use whatever you can, use visuals whenever you can. You don't have to have animations, computers, and all that stuff. You can use a blackboard, you can use an easel, you can use a blow-up of a document, you can use an Elmo and just highlight whatever you like on the thing. It's just as effective.
Jim told you that this was a 52-day trial, and he's only had a chance to tell you about 1 day of it. So after this is done, I'm sure he'd be happy to meet out in the halls with you and tell you some more.
It's good. It's got 2 months more to go.
At this point, we're going to turn to our students again, and again, a demonstration of a direct and a cross.
You don't mind being a judge for a couple of these?
I'm hoping you don't ask anything objectionable.
Good afternoon.
Good afternoon.
Could you please tell us your name?
Yes, my name is Dr. Chris Jensen.
What do you do for a living?
I'm a pathologist.
And Dr. Jensen, can you tell us a little bit about your educational background?
Of course. I graduated from the University of Texas with a degree in biology. From there, I went to medical school at Johns Hopkins. After attaining my medical degree, I then did a residency in pathology.
Dr. Jensen, what exactly is pathology?
Pathology is the study of possibly what causes a certain disease, or in some cases, what causes a death.
Now, after you received your residency in pathology, what did you do next?
It was at that point that I took a position as a pathologist at Cheapside Medical Center. I've been working there now for about 15 years, and I'm now the chief medical examiner.
This time, the state tenders Dr. Chris Jensen as an expert in pathology.
Any objection?
No objection, Your Honor.
He will be so received.
Dr. Jensen, how did you become involved with this case?
I was contacted and asked to perform an autopsy on Mr. Kittner.
And were you able to perform that autopsy?
I was.
Now, in performing that autopsy, did you also perform some tests?
Yes, I did.
And in addition to that, did you have the opportunity to review any documents?
Yes, I also reviewed all of the medical records of Mr. Kittner.
And doctor, did you form any opinions in connection with this case?
I did.
And were those opinions to a reasonable degree of scientific and medical certainty?
They were.
What did you base your opinions on?
Well, I based my opinions upon my education, my training, my experience as a pathologist, but also the autopsy, the tests that I ran during the autopsy, and my review of all of the materials in this case.
Now, before we get into what those opinions were, I want to ask you about some of the things you based them on. First, going to your autopsy, can you tell us, just briefly describe, what exactly is an autopsy?
Sure. An autopsy is an external examination of the deceased body, as well as an internal investigation of the internal organs in order to determine the cause of death.
Now, when you perform an autopsy, do you generally document your findings?
Yes, I do.
And Dr. Jensen, I'm showing you it's been previously marked as State's Exhibit 1 for identification. Do you recognize this?
I do.
What is that?
This is the report of the autopsy that I performed on Mr. Kittner.
And is that a fair and accurate copy of the autopsy report?
It is.
Now, are documents like this made and kept in the regular course of business at Cheapside Medical Center?
They are.
And when was this autopsy report generated?
I wrote this on May 12, 2011.
And who generated it?
I did.
This time the state moves to enter into evidence State's Exhibit 1, striking all marks of identification.
Any objection?
No objection.
So received.
Now, Dr. Jensen, can you tell us, during your autopsy examination, what observations did you make of Mr. Kittner's body?
Well, almost immediately I observed serious heart damage, Mr. Kittner.
Were you able to determine what caused that heart damage?
Yes, it was clear that Mr. Kittner had suffered from a myocardial event, also known as a massive coronary.
And when you say myocardial event and massive coronary, what is that in layman's terms?
It's more commonly known as a heart attack.
Now, were you able to determine by any chance what caused Mr. Kittner's heart attack?
I was.
Before getting into that, was that opinion to a reasonable degree of scientific and medical certainty?
It was.
And what did you base that opinion on?
I based my opinion upon the autopsy itself as well as a toxicology report, or toxicology test that I performed.
So, Dr. Jensen, going to a toxicology test, can you tell us what that is?
Sure. That's a test of a patient or deceased blood, or as well as bile. We would test those substances to see if there are any foreign substances within the bloodstream.
By foreign substances, what do you mean by that?
Anything that doesn't necessarily belong in the human body, such as drugs.
Were you able to find any drugs in Mr. Kittner's system?
I was.
And what drugs were significant to your opinion in this case?
Well, there were 3 drugs that were significant to my opinion. I was able to find propofol, adrenaline, as well as hydrocodone.
So, doctor, let's take those one by one. Starting off with propofol. What exactly is propofol?
Propofol is a surgical sedative that is commonly used in the medical field.
Now, did Mr. Kittner have any medical condition that would require him to use propofol?
Based upon my review of Mr. Kittner's medical records, there was no condition he was suffering from that required the use of propofol.
Now, what amount of propofol was in Mr. Kittner's system?
There was actually 3 times the normal dosage.
So in 3 times normal dosage of propofol, what effect does that have on the human body?
That can commonly lead to hallucinations.
Now, is that amount of propofol alone, is it deadly?
Most commonly, no. Propofol in that amount in itself would not cause death.
So why did it contribute to Mr. Kittner's death in this case?
Well, it was the mixture of propofol along with the other drugs that were in his system at the time.
So, doctor, earlier we talked about hydrocodone. What effect does it have when propofol and hydrocodone are mixed?
That can lead to a heart attack, most commonly.
Now, is it within the medical standard of care to administer propofol to a patient who's using hydrocodone?
Absolutely not.
And Dr. Jensen, is it a responsibility of a physician to know what drugs their patient is taking?
It is.
And is that something that a doctor should consider or take into account when they're administering treatment?
Absolutely.
Now, finally, doctor, you mentioned adrenaline as well. Can you tell us what that is?
Yes, adrenaline is a hormone that is created within the body itself, but it is also used in the medical field.
How is adrenaline used in the medical field?
Most commonly, it is used to prevent a person from having a heart attack who's going into heart attack-related symptoms.
And how is adrenaline administered?
It is injected.
Now, doctor, what effect does it have when adrenaline is injected into a patient who has both hydrocodone and propofol in their system?
Although it is commonly used to ameliorate the issues involved with a heart attack, in this case, because of the propofol and the hydrocodone that was already inside Mr. Kittner's body, it only accelerated this heart attack.
Would it be considered a gross deviation from the standard of care to administer adrenaline to such a patient?
Absolutely.
Dr. Jensen, based on your review of the medical records as well as your autopsy and toxicology test, were you able to determine to a reasonable degree of scientific and medical certainty as to what caused Mr. Kittner's heart attack?
I was.
What was the cause of his heart attack?
It is my opinion that it was the mixture of those 3 drugs in his system that caused his heart attack.
Thank you, Dr. Jensen. Nothing further at this time.
Cross, Your Honor.
You may.
Allowed. Dr. Jensen, you're a pathologist, correct?
That is correct.
That means you examined Mr. Kittner after he passed away.
Yes.
You didn't get the chance to examine him alive, right?
No, I did not.
You examined his heart after he passed away.
That's right.
And that examination showed you that he had a heart attack.
Yes.
But it didn't tell you when he had that heart attack.
I don't know the exact time that he had the heart attack, no.
And you get a chance to see Mr. Kittner's symptoms on May 9th, 2011.
I did not see Mr. Kittner on May 9th, no.
And so you don't know when Mr. Kittner's symptoms began on May 9th.
I don't know the exact time, no.
You were asked some questions about propofol and hydrocodone by Ms. Lemke just now, right?
Yes.
And you made a statement that when the two drugs are mixed, you stated, it most commonly causes heart attacks, right?
That's right.
Now you're familiar with something called the physician's desk reference.
Yes.
It's a compilation of information about drugs, essentially.
Sure.
And it's widely relied upon by doctors such as yourself.
Doctors do rely on it, yes.
And it talks about how certain drugs interact with other drugs.
Correct.
And specifically, there's a part of the PDR, the physician's desk reference, that talks about propofol.
Yes, I believe so.
The record reflect, I'm going to show the witness what's been previous smart defense exhibit 1 for identification. That's the page of the PDR on propofol, right?
Yes, it is.
There's a section there labeled drug interactions.
Yes.
That section discusses how propofol interacts with hydrocodone.
Yes, it does.
In fact, nowhere in this section does it ever say propofol and hydrocodone commonly cause heart attacks.
It does not say that here, but it commonly would lead to heart attacks.
Well, it doesn't say it in the physician's desk reference, does it, sir?
Not here, no.
In fact, this document, widely relied upon by doctors such as yourself, gives instructions on how to mix these two drugs, doesn't it?
Yes, it does.
It says that you just have to reduce the amount of propofol,
That's correct.
and that giving propofol when someone's on hydrocodone may elevate cardiac stress.
Yes, but here it clearly did.
Well, it may elevate cardiac stress is what it says in the PDR, right?
That is what it says here, yes.
Obesity elevates cardiac stress.
It can.
Drug use elevates cardiac stress.
It's possible, but that's not what happened with Mr. Kittner.
Well, drug use elevates cardiac stress, sir.
It can.
And a stressful, hectic lifestyle, that elevates cardiac stress.
Again, it's possible.
I want to talk about what you relied upon document-wise in coming to your opinions. You mentioned a toxicology test, right?
Yes, I performed one on Mr. Kittner.
I want to talk to you about some of the drugs that you didn't mention were found in that toxicology test. You found cocaine in Mr. Kittner's system, didn't you?
I found trace amounts of cocaine.
You found cocaine in Mr. Kittner's system, right?
Yes,
Cocaine elevates the risk of cardiac stress.
it can, but again, this was just trace amounts.
Well, cocaine elevates the risk of cardiac stress, we can agree.
It can.
It raises blood pressure,
Yes.
puts stress on the heart.
Yes.
You found ketamine in Mr. Kittner's system.
Again, just trace amounts of ketamine.
Trace amounts of ketamine.
Correct.
That's a tranquilizer.
It is.
That puts stress on the heart.
Yeah.
Mixing a tranquilizer with a stimulant like cocaine, that puts more stress on the heart.
It's possible.
You also found sodium hydroxide and aluminum powder.
Yes, trace amounts.
Trace amounts of a powdered metal in Mr. Kittner's bloodstream.
Yes.
Materials that would have had to have passed through his heart if they were found in his bloodstream, right?
Most likely, yes.
I'll talk to you about the 3 drugs that you mentioned on direct examination. First was that adrenaline, right?
Correct.
You found adrenaline in Mr. Kittner's bloodstream.
That's right.
But that didn't tell you who gave him the adrenaline.
No.
It didn't tell you when he was given it.
Again, I don't know the exact time, no.
You found propofol,
Correct.
but that didn't tell you who gave it to him
I can't say for sure, no.
or when.
No.
You found hydrocodone.
Yes.
That didn't tell you who gave it to him
Again, no.
or when.
No.
And in fact, that test, it doesn't tell us how much hydrocodone Mr. Kittner had in his bloodstream.
I was not able to determine that from the toxicology report, no.
So it's fair to say, as we sit here now, we really have no idea how much hydrocodone Mr. Kittner took on May 9th.
It was enough to cause a heart attack.
But we don't know how much he actually took.
I don't know the exact amount, no.
You conducted an autopsy,
Correct.
and you spoke about the steps of the autopsy, right?
Yes.
One of those steps is making physical observations of the body.
Certainly.
An important step,
Yeah,
because making those observations can help you determine cause of death.
they can.
In this case, cause of death was a heart attack,
It was.
and you made some physical observations in determining that.
Yes.
You made the observation that Mr. Kittner was obese, right?
Yes, he was.
He was 65 years old,
Correct.
but he looked older than 65, in your opinion.
Yes.
And he had a reason, you had a reason why he looked older than that.
I mean, I made an assumption.
Your assumption was that it was due to what you call his rock and roll lifestyle.
Yes, but I do not believe that that's what caused his death.
I'm just asking about why you thought that he may have looked older than he was, right? You contributed that to his rock and roll lifestyle.
Yes.
And by that you meant what we all know, his partying, right?
Sure.
Drug use,
Yeah.
stressful lifestyle.
Yes.
A stressful lifestyle damages the heart.
It can.
Drug use damages the heart.
It can.
Cocaine use specifically, that damages the heart.
It can.
And when you examined Mr. Kittner's heart, you found damage, right?
Yes. Massive damage.
You spoke about some medical records that you relied upon. Those are Mr. Kittner's medical records, right?
Correct.
I want to draw your attention to a specific one you found from the Golden Dock Healthcare Clinic. All right, I'm going to show it to you. We'll mark this Defense Exhibit 2 for identification. Now, this is an intake form, basically, right?
It is.
It's a form that Mr. Kittner filled out when he went to go see a doctor at a Golden Dock Health Clinic.
Correct.
And he filled out a bunch of information about symptoms he was suffering from
Yes.
and symptoms he had a history of.
That's right.
First, let's talk about the symptoms that he said he either suffered from or had a family history of. He said yes to dizziness on this form,
He did.
yes to fainting spells on
Correct.
this form.
Sure.
Going to the symptoms that he's complaining of on this day, he filled out this form April 21st, 2011.
That's correct.
That's about 18 days before he unfortunately passed away.
Yes.
And he talks about why he came in to see this doctor.
He does.
He has difficulty breathing.
Yes.
He talks about how this problem begins.
He does.
Said he was having a beer with some friends and all of a sudden he couldn't breathe.
So what do you put down here?
He says that he's been having this problem for 48 hours prior to even coming into this doctor's office.
That's what it says here.
And that was on April 21st, 2011.
Yes.
And 2 weeks later, he was dead.
Correct.
Nothing further.
Any redirect?
Yes, Your Honor, briefly. Dr. Jensen, you said earlier that you were able to examine the heart of Mr. Kittner independently. Is that right?
That's correct.
Did you find when examining the heart any constricted blood vessels?
No, not at all.
Did you find any damage to the arteries?
No, I just saw the massive coronary.
Besides evidence of the massive coronary event that occurred that day, was there any other damage to Mr. Kittner's heart?
None that I found.
Thank you. Nothing further.
Thank you, counsel. Alan, we're at the point where we're supposed to let everybody go home.
Right.
But if you can, briefly, why don't we bring this back to how these folks can use what they've heard and seen in their daily practices?
Yeah, I'm not sure I can do much in 30 seconds, but I guess the point is we do work a lot without a whole lot of preparation and then without a whole lot of documents. So when I'm doing and I want to really focus on cross-examination. So cross-examination, you're doing it because you have something you want to establish. And you can do a couple of different things with cross-examination. You can establish something that helps you. So you may have a defense witness who is going to agree with you on a whole bunch of stuff, which will help build up your own client's credibility because it comes from them. So don't always think of cross-examination as a way to tear a witness down. Often you can get things that may not be controversial in the case, but absolutely give your client credibility, set the background, and all kinds of things that they'll agree with you with, which help your client out. So for example, I represent a disabled man who's in a building, he's being evicted, and one of the issues is whether or not his disability was in fact the reason for his eviction. And on the front page of the lease, it says, this is a building for people with physical and mental disabilities. So when I'm cross-examining the property manager, I start right off with that, saying the whole purpose of this building is to put people who are disabled into it. And she agrees with me. So that, and go through all the things in the lease to talk about disabled people being there, the application, how you have to qualify to get in this building, you have to prove you're disabled. And so it sets the stage for the jury that it's perfectly reasonable that a disabled person would be in this building, why they're in this building. And all of that then gives my client some credibility when he stands up and talks about his disability, because they've already heard from the other side all this nifty stuff about disability. So you can don't only think of cross-examination as a way to attack their case, think of it as a way to help your own case. Other times you really are doing a cross-examination to attack the credibility of their witnesses. We just tried a case where the big issue was whether or not it was a CHA eviction. The issue was whether or not the son who had been arrested because he had failed to register as a sex offender actually lived in the apartment or not. And the main evidence that the landlord had was, according to the police report, mom had admitted that he lived there. So that was basically the case, and she denied doing it. So we had the police officer on the stand, and police officers are generally pretty good at testifying because they do that a lot. They're pretty professional testimony, and I knew I wasn't likely to shake them off of what was in the report because it was right there in one of these police reports that, in fact, that's what mom said. What I found with police officers, though, is that they're really bad when they get off the police report. So one of the ways to attack their credibility is ask them about all the other things that aren't in the police report. What were they doing before this? How many arrests did they make that day? Was this the only arrest? What did they do after this? What route did they take to the building? Did they come in from the east? Did they come in from the west? What does the building look like? Some of those things they knew. A lot of them they had no clue about because it's not in their arrest report. So what do they know? Then I threw one in about the weather. What was the weather like that day? Not in the police report. It was February, so they said it was really cold and bright and sunny out. And they just moved on. And the kid wasn't there. Mom had called the kid, so mom's story sounded really nice. The kid wasn't there when they arrived, and mom voluntarily called the kid and brought him over there. So I went through all that with the police. The mom was very cooperative. Police didn't secure the scene. They just walked into the living room. They all sat around and chatted while they waited for the kid to come. Again, not what you think of as a high-pressure situation. And then at the end of the cross-examination, I pull out the Sun-Times. And in fact, the weather that day, this was 2 days after our huge snowstorm, and everything was closed in the entire city. And they hadn't mentioned snow. They just said bright and sunny. And the judge, and I asked the judge to take a judicial note of it, and he said, yes, I remember this very well. The courts were closed until the day of this eviction happened. It was the first day the courts were back in business. So yes, I'm going to take judicial notice of it. So that right there leads on things that aren't necessarily relevant to the case, but it's all those details, and that's why those detailed facts can be really important, and that's why with your client, you want to get those details in, because that's the way people remember reality, is all the things that happened around it. Whereas when police officers, or landlords for that matter, are trying to reconstruct something, they're going to base it on what's written in the document. So what isn't written down is often very important. The other way you can contradict people is the documents that ought to exist out there, or things that people ought to do, and that's what you all talked about. So example again, for the same case, the issue is whether or not he lived there. They arrested him and charged him with failure to register, but they didn't charge him with living in a place that he wasn't allowed to live. That is, the reason he wasn't registered, at least the landlord's theory was, the reason he didn't register with mom is because it was too close to a school and therefore he couldn't live there. So he was read, but he was not charged with living where he wasn't supposed to be. He was only charged in those technical violations. So I made that very clear to the police officers. And then it turned out, the police officers gave me, unexpectedly, because I had no idea this was true, that in fact they couldn't charge him with that because he could have lived there. There wasn't anything actually wrong with him living there. So that sent to the trier, it was a bench trial actually, but it was sent to the trier of fact that this is really not an important issue. Nobody was at danger here, and therefore it's not like it's a big deal to rule in favor of the landlord. So again, what should have happened if in fact what they're saying was true, this was a horrible thing, didn't happen, and it turned out to be really good for our side. So you don't have to be Perry Mason and beat people up on the stand and get them to admit that they're lying, because it's not going to happen. You want to use all of the other facts that you can get, all the details that they're not likely to know if it didn't actually happen the way they said it did, to cross-examine them and make them look like they're essentially reading off the report. The final piece was that while there was a police report that said that mom had said this, they didn't call that cop to testify. They called one of the other police officers who had filled out a different report, who didn't include that in there, to testify that he had heard it. So you can use all the cross-examination about the police reports are really important. You would write down everything in there that's really important that was said, and you knew that you were trying to charge this kid for it, and now you're here trying to say it, and read here's your copy of the report you filled out. Does it say anywhere in here the statement that you're now saying mom made? And he's like, no, but somebody else. And then I said, objection, hearsay. They were talking about somebody else, and none of that got in. So again, what should be in a report, what should be in a document is often just as important as what is in the document. And juries take documents really, really seriously. This is the lesson I learned in my very first jury trial. It was another CHA eviction, and the issue was whether or not, back then, whether or not the child had committed a crime on the CHA premises. And the whole argument was whether or not it actually happened in the apartment or somewhere else. And we had this long argument. The jury was out for 2 days, and none of us could figure out why the jury was out for 2 days. And the jury was out for 2 days because those of you who do CHA leases know that the lease is pretty thick. And we gave the jury a copy of the lease that was in evidence. And we asked them what took 2 days. And they said, well, you all were arguing the entire trial about what this lease said. So we all wanted to read the lease. And that took us a day and a half. And then it took us about an hour. We ate lunch, and then we all voted, and you won. So it was a good lesson that they really took this seriously. Even though we were all arguing about one paragraph and we thought it was really, really obvious what the paragraph was, they wanted to read the lease for themselves. And we only gave them one copy, so they spent 6-7 hours each trying to read through the whole lease. So juries take these cases very seriously. The fact that they don't miss details, I think, is absolutely true. They will look at everything that you give them, and they will listen to everything that's said, and that's why, to the extent you can point out testimony that diverts from the documents, particularly if it's a document that the other side is putting into evidence that contradicts it, that's really, really important. So even if you haven't got a whole bunch of depositions and you haven't got a whole bunch of interrogatories, we usually have interrogatories, but often we don't have depositions for all the witnesses. Use the documents you've got, use the facts that you know exist out there because you've been to the scene again and you know what you're looking at, to try to cross-examine people and attack their credibility on things that may not be the central issue that they're all prepared to testify about.
I think it's fair to say that we all have a lot more we could have said today, but it's also fair to say that you've been very patient with us, and it's time to end everybody's agony. But thanks to the panel, thanks to our students, thanks to all of you for coming. We hope you've learned something.